Good afternoon, everybody. My name is Kathy Purdy. I am the marketing manager at Schoeneck King. I'd like to welcome you to this week's coronavirus update and discussion on continuing legal and practical issues. Just two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of the screen, and our presenters will do the best they can to get to those as time allows. And once the webinar has completed, please take a moment to take the brief survey at the conclusion. So to start today's program, I'm going to turn it over to Pete Jones.
Thank you, Kathy. Good afternoon, everyone. We've got another full program for you today. We're going to kick it off with some discussion about various aspects of the executive order, the unemployment insurance provisions and the payroll tax provisions, a couple of separate presentations on that. We will do an update from Albany, kind of a normal feature that we have here, what's going on, what are the latest developments out of Albany with respect to reopening and the COVID management issues. We're going to talk a little bit about some reopening, basically FAQs. We're getting recurring questions, so we thought we'd try and knock off, a handful of those and anticipate some questions, but also answer some of the most frequent ones that we're receiving. And then as we get closer and closer, everyone's keeping their eye on the school reopening. So we're going to talk a little bit about that this afternoon. It obviously has broader implications than just, the schools because of the daycare aspect of it, the people managing their families, et cetera, et cetera. So we're going to start today with Mallory Campbell. Mallory's in our New York City office, and she's been following throughout this, kind of unemployment insurance. So Mallory's going to talk about where we are now and where this stands. Mallory, take it away.
All right, thanks, Pete. So it's probably been a little while since we talked about unemployment benefits. So just as a little refresher, the CARES Act, which was enacted back in March, provided for enhanced unemployment benefits. It expanded coverage to people not normally covered, including independent contractors. It provided for an additional 13 weeks of unemployment insurance through the end of the year, and it provided for the additional $600 per week in compensation through the end of July. So all of these benefits are fully reimbursed by the federal government for private employers. For nonprofits, since they don't typically pay unemployment insurance taxes, they usually have to reimburse the state for any unemployment benefits paid to former employees. However, the CARES Act, under the CARES Act, nonprofits are entitled to 50% reimbursement of these costs from the federal government. So nonprofits would have to pay 50% of the cost of unemployment insurance to the state, and the federal government would cover the other 50%. So originally it wasn't clear whether nonprofits would have to pay this upfront, 100% of the cost upfront, and then wait for the 50% federal reimbursement, or if they would receive federal help from unemployment payments in advance. So this was just clarified. President Trump just signed into law an act that explains that instead of requiring nonprofits to reimburse the state immediately and then wait for that federal aid, nonprofits are only required to provide that 50% in payments to the upfront. So this is something really helpful to nonprofits. Another big update, as I'm sure many of you are aware, the extra $600 per week in benefits expired at the end of July. So specifically in New York, this ended on July 26. Since that time, Congress has tossed around several bills trying to extend these benefits, either at this $600 a week rate or at another rate. However, none of these bills have gained traction. On August 8, 2020, though, President Trump signed a memorandum which provides up to an extra $400 per week in unemployment benefits to claimants. This program is known as Lost Wages Assistance and is funded 75% through FEMA's Disaster Relief Fund and a 25% state match. As originally passed, this program required that states pay an additional $100 to claimants, then the government would provide the additional $300. However, after some backlash, the Department of Labor has made clear that states can count funds that they're already using to provide the regular unemployment payments. So basically, as long as the state is paying the claimant a weekly benefit rate of at least $100, then that claimant would be entitled to the additional $300 from the federal government. However, states can still choose to provide an additional $100 on top of that if it chooses. So states pretty much have three options. They can just provide the additional $300 from the federal government on top of the weekly benefit rate. And again, that would only go to claimants that have a weekly benefit rate of $100 per week or more. States can pay an additional $100 on top of $300 in federal aid, or states can do nothing. So states don't have to participate in this program if they choose not to. So far, a little over half the states have applied and been approved for this program. And out of the states that have applied, most are just doing that extra $300 in federal aid and not the additional $100 on top of that. On Sunday, New York was approved for this program, and based on Governor Cuomo's comments, it looks like New York will probably just be providing the additional $300. Recipients would get back pay dating to the week ending August 1, so this would fill in any gaps between when the $600 benefit ended and this current benefit. This aid is scheduled to expire on December 27, according to the memorandum, but it's likely going to expire much earlier. So there are three circumstances under which the aid will end early. The first is if FEMA spends the $44 billion from the disaster relief fund that was set aside for the lost wages assistance. The second is if the total balance of the disaster relief fund decreases to $25 billion. Or the third is if Congress ends up enacting legislation that would provide supplemental federal unemployment compensation. FEMA has estimated that its funding will run out for this program much sooner than December 27. It's looking like they're thinking about 4 to 5 weeks. So initially, states will get an initial 3-week grant from FEMA at first. After that, FEMA will determine how much more is available. How much more is available will obviously depend on how many states end up applying to this program and how many claimants each state has to pay. So another issue that is unclear is when people will actually start receiving this additional benefit. So states are going to have to reconfigure their systems to comply with this and be able to distribute the funds. So it likely won't arrive for several more weeks. But we'll sure to keep you updated on this topic, and that's all we have for now on this. So I'm going to hand it back to Pete.
So Mallory, thanks. So high-level summary, if you could just keep your mic open for a second, is that it looks like we're going to go forward with the $300 in New York, additional $300 per week. Question will be how long that funding lasts, and the question will also be, when it kicks in terms of being effective. Is that a summary of where we're at this point?
Yeah, so the payments will be back through the week of August 1. It's just not clear when that money will actually be available.
The other question we have here, Mallory, before we move on is, what are we doing, or what is the state doing on, claims that were fraudulent or misuse of the system types of claims. And I think our latest information is that New York has been so busy trying to process the actual claims that they really haven't been doing anything meaningful on the fraud side. And that if you can get a hold of somebody at DOL with information, you might be able to move that up in the queue. But in the ordinary course, there hasn't been a lot of activity on fraud because they've just been so busy with the claims. Do you have anything additional on that, or?
Yeah, that's pretty accurate. There is a hotline number, I don't know it off the top of my head, for reporting fraud that would be helpful for anyone facing that issue. But it is something just kind of not really taken too seriously right now, just because there's a lot of other stuff they have to deal with.
Maybe we can push that out in the chat to everybody as we move on. Thank you for that. Let's move to Jessica. Jessica's in our Albany office, and she's going to cover another aspect of the executive order, and that's the payroll tax update. So where are we now? Part 2. Jessica, take it away.
All right, thanks, Pete. So I'm going to give an update on the payroll tax deferral measures that have been implemented via the CARES Act and now presidential memoranda. For some context, you may recall hearing about this from Erica Wood. I know she wrote about it in her April 16th business tax update, and I believe spoke about it before. So initially, the CARES Act allows employers to defer depositing and remitting the employer portion of Social Security taxes incurred from March 27th to the end of this year. The purpose of this was obviously to create some much needed cash flow for businesses, and the deferred amounts are due in 2 equal installments, one on December 31st, 2021, and the other 50% is due December 31st, 2022. So this and other guidance came out from the Treasury. So now, recently, by presidential memorandum issued on August 8th, President Trump expanded this tax deferral to include employees as well. So what this means is that employees can now defer the withholding, deposit, and payment of the employee portion of Social Security, which is currently 6.2%. And note that this is only the OASDI tax component and not the Medicare component, which I believe is another 1.4%. So this applies to wages paid from September 1st, 2020 to the end of the year. So it's a little bit shorter time period than the employer portion. This applies to employees whose wages are, quote, generally less than $4,000 biweekly, calculated on a pre-tax basis, which is equivalent to about $104,000 a year. And like the employer portion, the employee portion will be deferred without any penalties, interest, or any additional costs or fees associated with the deferral. So in the memorandum, the Secretary of the Treasury, again, was directed to issue guidance on this, and we haven't seen anything yet, and there's no time frame by which he has to issue something for businesses to follow. We're hoping to see something by the September 1st start time, of course, but if not, we're going to have to deal with what happens in the interim for businesses when there's absolutely no guidance on this. So once we get there, if we get there, we'll cross that bridge and try and figure something out. So when guidance is released, though, I think we might be expected to see something similar to what was issued for the employer portion, maybe deferral for at least a year, payback in chunks, 50%, 50%. But until we see anything, we just kind of don't know yet. So some questions that remain and that we will be on the lookout for, and maybe you want to be on the lookout for as well, is participation in this deferral mandatory, or is it elective for employers? Kind of on the flip side of that, can employees choose to opt out? Is it going to be an opt-out policy? Will it be opt-in? I know some employees might not want to defer these taxes and then get saddled with a huge bill later on. So that's something that we're going to look out for. Another question is, how long will employers have to modify their payroll reporting systems to comply with the guidelines once they're released? I know that sometimes implementing changes to payrolls takes a while. It takes a minute to update. So something that was mentioned is maybe there would be a retroactive application of this deferral in case, the system can't catch up for a couple weeks. And then another question is, what is meant by generally less than $4,000? Does it include bonuses, overtime pay? And what if an employee has more than one job? Is that $4,000 wage threshold, is it per employer, or is it going to be an aggregate? And if it is an aggregate, what responsibility does each employer have to confirm eligibility? And this is another big question. What happens if an employee quits or leaves employment between September 1st and the end of the year? Will employers be required to pay the money out of their own pockets if they can't get it from the former employee? And especially if they can't get it from the former employee until after this program ends, which is the end of the year, can employers collect prior to January of next year? And finally, there's talk about eventual forgiveness of this deferral. The memorandum instructs the Secretary of the Treasury to, quote, explore avenues including legislation to eliminate the obligation to pay the taxes deferred pursuant to the memorandum. So it's likely that any forgiveness will have to go through Congress for funding, which is just going to add one more layer of uncertainty. A lot of these questions we just can't know until we get guidance from the Treasury. So we'll be on the lookout for that. And if you have any questions, feel free to email us or get in touch. So back to you, Pete.
Jessica, thanks. I mean, a lot of unanswered questions here, obviously. So we'll keep our eye on this. We'll continue to do updates in this session, and we'll also do written updates that we'll push out to our clients as information becomes available. Okay, let's turn now to Katie Anderson. Katie's going to cover some of the developments in Albany as she does on a weekly basis. Katie, take it away.
That's right. Let's qualify by saying only some of the developments because I could never cover them all. There are always many of them. So first up, we have, of course, our update to the travel advisory. This came out, breaking news, came out an hour, within the hour. We saw 5 states removed: Alaska, Arizona, Delaware, Maryland, Montana. I actually put this map together before I heard the update that Guam was added. So Guam has been added. So I, apologize if you're taking a trip to Guam. One thing that's going to be important here, and this is a question that's been coming up more and more frequently, my question mark at the bottom that says international quarantine. The CDC removed the requirement that when a person travels internationally, they have to quarantine for 14 days upon return. So what does that mean? Will New York, the big question is, will New York put an international quarantine in place? I think it really all depends. If we see cases in other countries begin to spike, we see, in Italy's scenario, what happened in Italy in March, I think that New York will put one in place, likely using the same metrics. But, this becomes a harder issue in the fact that it's the federal government is really the entity that's supposed to be in charge of these international types of travel issues. So I'm not sure that New York State will put one in place. Right now, really, the executive order that requires quarantine from these states does not cover international travel. So remember that. They would likely need to put out another executive order or affirmatively state that the quarantine is required. So that is, where we're at with that international quarantine. Again, just not really sure that that's going to happen. But one other thing to know is that, Americans, really practically speaking, Americans can't go that many places. Most countries aren't letting us in. So it's really a question of who wants to come here at this point. Turning then to other issues that are happening. There was a major executive order that came out yesterday about election procedures. This really impacts municipalities in a large way. First, the governor signed a package of legislation regarding absentee and mail-in voting. Basically, any person in New York State, any registered voter, can request an absentee ballot using basically the risk of contracting COVID-19 as the excuse. But remember, you have to affirmatively request that. This executive order came out last night, 202.58, requires boards of elections to send out voter information, and that includes information about early voting and requesting absentee ballots. That has to be done within the first week of September. I believe the date is September 5th it has to be done by. So that's coming up very quickly. Also adding a 5-day cure period for deficiencies regarding absentee ballots if they're received after November 3rd, on or after November 3rd. Basically just trying to come up with ways that voters can rectify what's wrong with their ballots absentee ballots can be confusing with the witnessing box. I received an absentee ballot in an election and I was confused by it. And this is what I do. So it's a pretty confusing thing. Turning to just miscellaneous updates then, because I can't fit this all in under any one slide. We're looking at, New York's numbers have been steadily low, under 1% infection rate in New York, still have 500 people in New York being hospitalized. New York has a higher number of people that have COVID than other states, but has a much lower infection rate because our population is so much larger. Looking at, outdoor learning, the mayor of New York City announced yesterday that New York City is considering outdoor learning and that schools basically need to have a plan in by this week regarding outdoor learning. Really, I put these two bullets about schools in there to just show and really tee up that schools, it's a state of flux. What's happening today, a month from now, who knows where we're going to be with schools. And that is, a very uncertain future. One other thing to note, this is COVID related actually. You see an expansion in where Narcan is going to be available. So this was a piece of legislation signed yesterday by the governor. This allows restaurants, bars, retail stores, all of those places that I've listed there can now carry Narcan, which is, it helps, eliminate an opioid overdose if one occurs. These places can carry them. They are not mandated to carry them. But the real push behind that was we've seen a spike in opioid overdose as a result of quarantine, as a result of being locked in homes. And with that, that is our Albany update. And I am done. Thank you.
Katie, I think this was probably implicit in the way you framed the issue, but I think some folks have posed the question about whether the CDC's removal of quarantine requirements will lead New York to do the same. You kind of went the other way, which is, will New York impose international quarantine requirements? But what's your thought on the idea of whether New York will do away with the travel advisory at any point in the near future?
I do not think New York will get rid of this travel advisory while COVID is still happening in New York or in the country. I mean, just period. It doesn't matter what the CDC is doing internationally. New York does not want people, really to come into the state with COVID. I've seen quite a few articles, think pieces about whether or not New York is going to remove the quarantine based on what the federal government is doing. But New York has continued to have significantly higher standards than the federal government and requirements regarding COVID-19. I don't see that stopping now. Okay, great. Thanks. That seems to be kind of a consensus view, at least from what we're able to glean. Let's turn now to Adam. We have had, Adam's been on a bunch of times, and, we're calling this reopening, where are we now, part 3. But, we do have a moment, I think, to take a breath here because we are, most of the stuff that's been out has been out for a while. That doesn't mean that people don't have a lot of questions. And we're going to pick some of the ones that are most frequent and seem to be most on people's minds, and Adam's going to tackle those right now. So take it away, Adam.
Pete, thanks again for having me. I'm happy to be back to talk about these reopening issues again. Like Pete said, we've all had a chance now to digest the guidance, the requirements. And so I'm going to cherry pick a couple of issues that keep coming up regarding testing, vaccinations, and then leave. So let's start off with testing. The first question, and I'm going to proceed through this in a basic to more complex question analysis. The first very basic question is, can you as an employer require your employees to get tested for COVID-19 before they return to work? The answer is yes. The EEOC said very early on that that was permissible. So the next level of question would be, okay, if I'm going to require surveillance or return to work testing, who's going to pay for it? So initially, there was, as everyone probably knows, the FFCRA, the Families First Coronavirus Response Act, and the CARES Act provided that insurance companies would have to pick up the costs of certain testing and treatments for COVID-19. Unfortunately, on June 23rd, the United States Department of Health and Human Services, Department of Labor, and Department of the Treasury released some FAQs that addressed this question. And they clarified that insurance companies do not have to pay for surveillance or return to work testing. So that is no longer an issue. If an employer is going to be requiring an employee to obtain a test to return to work or for surveillance purposes, then they are most likely going to have to pick up the bill for that testing. Now, the next level of question is, well, what if an employee refuses to take a test? And I think that this analysis starts with asking the question, why? What is the basis for the employee's refusal? Because that will determine how the employer acts. For example, if an employee refuses to take the test for disability or religious related reasons, an employer will want to take a different approach. They may want to accommodate the employee in a different way, whether they require additional safeguards while the employee is at work by requiring masks at all times, or allowing the employee to continue working from home if they were already, or allowing them to begin working from home if that's feasible. If an employee simply does not want to take a test because they don't want to take a test, an employer can take a different approach, and they can impose discipline if they want, potentially give the employee an unpaid leave, or potentially impose discipline under any progressive disciplinary policy that the employer has in place. So those are some frequent questions that we're getting about testing. We've also been getting questions about flu vaccines, and we're not at the coronavirus vaccine yet, but we have some established precedent to help us understand how to analyze the flu vaccine question. You're an employer, you want your employees to get vaccinated for the flu, can you require them to do so? So this is a more difficult question than the question about whether you can require COVID testing. Historically, certain industries have been permitted to allow or to require their employees to get vaccines. For example, in the healthcare industry, employees are sometimes required to or are required to have certain vaccinations. The general rule is that requiring vaccines is permissible so long as you provide for exemptions for certain individuals for disability-related reasons, for religious-related reasons, or for pregnancy-related reasons, for health condition-related reasons. The EEOC actually released some FAQs on this particular issue, making it clear that an employer can't require an employee to get a vaccine if they have any of those reasons, the disability-related, pregnancy-related, or religious-related reasons for refusal. The EEOC encourages employers only to encourage vaccinations and not to require them, but the EEOC does not take the position that employers cannot require vaccines. Now, if you're an employer and you want to require the flu vaccine, you should take a couple of steps. First, you should check your collective bargaining agreements and or any other employment agreements to make sure that there are no restrictions on what testing you can provide or require of employees. Not just testing, vaccinations. You should have a clear process in place for an employee to request an exemption from the vaccination requirement. So a clear process for how an employee can tell you that they have some qualifying reason for being exempted from the requirement. You should also determine whether or not there will be specific accommodations for employees who are exempted from the vaccination requirement. So for example, if someone is exempted from the vaccination requirement, are you going to have additional PPE that will be required? Are you going to require them to wear masks at all times? Things like that. Have a clear plan in place for how you're going to address accommodations for employees who are exempted. So that's a very, very basic and brief overview of the vaccination question. But again, we only have 8 minutes here, so I'm trying to pack in as much as I possibly can. The last topic I wanted to cover that we are receiving quite a few questions about, and I know that a lot of employers are struggling with, is how to address or deal with leave requests from employees. And we're seeing a couple of areas where employees are making these leave requests. One, they're related to school reopening. So you have parents whose students are, or whose children are going to be only going to school 1 to 2 days a week, or maybe no days a week. And employers are struggling with the question about how do we respond to those requests? Well, I think that there's a couple of steps. First, you should review your existing leave policies, whether you have sick leave policies, your FMLA policies, telework policies, attendance policies, etc., and try to figure out what your existing policies say. You should also understand, and I think this is the area that I'm going to focus on right now, understand the interplay of the federal and state COVID statutes and these leave requests. So as we've talked about in these webinars many times, there is a federal statute called the Families First Coronavirus Response Act, and there's a state statute that provides for emergency paid sick leave. The federal statute has 2 different kinds of leave for employees. One is expanded FMLA leave, which is 10 weeks of paid leave, and the other is emergency paid sick leave, which is 80 hours of paid sick leave. So with respect to the school closure question, the analysis may go as follows. You ask your employee why they're requesting leave, and they tell you, my son or daughter's school is closed, or my son or daughter is going to be home from school because their school is going to be operating under either a hybrid model or a completely remote model. I think you need to obtain some additional information from the employee. We know that states, at least in New York, or schools, at least in New York, are allowing parents to make a decision about whether or not they are sending their children to school part-time, full-time, or entirely remote. So if an employee is choosing to keep their child home, then they wouldn't necessarily qualify for leave under the Families First Coronavirus Response Act. They also wouldn't qualify for emergency paid sick leave under the state law because that requires a quarantine order. So the only potential leave that they would have available to them is either the expanded FMLA or the emergency paid sick leave under the FFCRA. So the other question that you would want to ask is, the other issue that would arise is whether the employee is going to be entitled to intermittent leave. So intermittent leave is when an employee takes a portion of the time off, whether it's a couple hours at a time or a couple days at a time. And the availability of intermittent leave under the FFCRA is kind of up in the air following a decision, court decision from the Southern District of New York, which seems to have invalidated a provision in the Department of Labor regulations, which only allowed intermittent leave if an employer agreed to it. Now, we don't know the full extent or application of that decision, whether it applies everywhere or whether it just applied in that particular case, but that's an issue that muddies the waters a little bit with respect to intermittent leave. So as an employer, I think that if you have employees that are coming to you with these school-related issues, make sure you're checking with your counsel. If you have a good handle on the FFCRA and its rules and regulations, you should still check with your attorney. Make sure that you're following the appropriate requirements of that statute. We're also seeing leave requests related to travel. Katie talked about the travel advisory. Everyone has been dealing with this travel advisory. At this point, we've all had employees, all businesses have had employees who've either gone on vacation or traveled to one of these hotspot states. So when an employee returns, the issue is, are they entitled to paid leave under either of those 2 COVID statutes? The state has made it clear employers are not entitled to paid COVID leave. If they travel voluntarily to one of those states and you've provided them notice that they wouldn't be entitled to that leave. The answer under the federal law, the FFCRA, is less clear. Employees may potentially be entitled to FFCRA leave because they are subject to a quarantine order. But again, make sure you're checking with your attorney to ensure that you are following the federal and state requirements in that regard. So that's all I have, Pete. That's a quick overview of these common questions that we are still getting. So I hope that was helpful.
Thanks, Adam. A couple of quick ones here. Someone has asked whether, in light of New York's low infection rate, is there any chance the governor will eliminate the screening questions that employers must ask each day? Had a similar question come in about whether or not the travel advisory would be lifted. And I think Katie's already spoken to that, but for my money, I think the answer to that is that's very unlikely.
Yeah, I mean, I think that we've seen from Governor Cuomo that he's going to be conservative in his approach to the virus. The state just I know it seems like these requirements have been in play for a very long time, but they really haven't. We're only looking at a month or two that they've been in place. So I don't see them being lifted anytime soon. I completely agree with Katie's analysis.
Second series of questions about, PHI, protected health information, and what happens if someone tests positive, and or what if someone requests an accommodation in the vaccine situation? Does that somehow impinge upon their privacy rights? And I'll tee it up a little bit and let you comment, but it seems to me that we have to distinguish between, first of all, whether it's actually PHI, protected health information, or whether it is, simply a step or two removed from that. That is, we're not talking about someone's diagnosis or treatment, but, it may be, obvious to folks that there's something going on, but it's not clear what it is. And so that's a step removed. The other is that these are not technically HIPAA situations, I don't believe, but any thoughts on those?
So is the question dealing with whether we can have an employee request an exemption or fill out a form requesting an exemption?
No, I think it's more that if you have vaccines and then someone's wearing the mask all the time, as you alluded to, that won't that sort of out them to the rest of the workforce?
Oh, I see what you're saying. I don't think so. I mean, this would be an accommodation that you are giving as the employer to the employee who has requested that they be exempted from the vaccination requirement. So I don't think that would be a situation where you would be disclosing any protected health information.
Okay, I agree. Thank you. Let's move to Kate. Want to make sure we save enough time for her to give us an update on a topic that's really on everybody's mind every day, I think, and that's where are we with the school reopening?
Great. So thanks, Pete. So happy to be speaking with you folks today. I represent our school district and private school clients at Bond, so happen to be in the weeds on these school issues as we approach the reopening of school. So not a lot has changed since the update I provided last week. Essentially, the current status is that plans were all due to the state by August 7th. So all plans have been now posted on school district and private school websites, as well as now centralized in a central repository maintained by the New York State Education Department. Those plans vary in terms of the approach that's being proposed. I mentioned last week that one of the requirements was that in putting together the reopening plan, districts had to plan for every contingency, meaning they had to have a plan for remote learning, a plan for hybrid learning, meaning a combination of remote and in-person, as well as in-person. What we're seeing now is that there seems to be a slow progression towards a delayed start in a lot of districts and schools. Here in central New York, there are 3 small city school districts that went public in the last 10 days to state that they are not, that, you know, for whatever reason, they are not at this time comfortable going to remote instruction yet. And as a result, they will be delaying their start. 2 of those districts are going to be waiting until the first week of October to go in person. I believe another district is going in person the last week of September. So what does that mean for all of you as employers? It means that you are unfortunately continuing to have to deal with this limbo that we were in the spring, where potentially a large portion of your workforce is not going to have in-person schooling available to them. It's important, going back to Adam's point regarding the FFCRA and the availability of leave time for that time, it's important to note that there are some distinctions right now between the status of schools now versus the status of schools in the spring during the COVID closure. During the spring, there was a COVID closure. In other words, there was an order of closure ordered by the government of statewide applicability. The governor closed all schools. Schools are not able and legally permitted to be open. That is not the case. The school closure order has now expired. School districts have been given local flexibility by their regulators to be able to decide when and how they will open. And as a result, certain districts are electing remote instruction either on a partial basis so they can comply with the Department of Health guidance, or on a full-time basis, but for a fixed period of time, maybe for 3 weeks or 4 weeks, until they can get everything in line to be able to go in person. One of the issues that is making school reopening complicated, of course, is the labor management issues. The majority of schools in New York State are public sector schools that are governed by the New York Taylor Law, and as a result, are used to needing to negotiate and navigate every situation that has labor relations consequences with their various collective bargaining units. An interesting development that occurred since I reported last week is that the New York State United Teachers, the statewide union that represents all teachers in public schools in the state, actually issued a statement to its members last week that reflects that that NYSET is taking the position that remote instruction is actually not mandatorily negotiable. That the school districts have no obligation to engage in collective bargaining regarding the reopening of schools if it's on a remote instruction basis. The union has taken the position that whether to offer services in person versus remotely goes to the fundamental function and purpose of the school, and the school has management prerogative to utilize remote instruction in lieu of in person. So this was a great development for a lot of schools that particularly the reaction from unions has varied, from district to district around the state. And there have been a number of unions that have been very, very strenuously objecting to remote instruction. Likewise, there's been some that have been objecting to in-person instruction because they don't feel that this situation is safe. It appears that at least at this time, NYSET has made a policy determination that they would rather fight the fight of safety, it appears, and to make the argument that their unit members should not have the obligation to return to school if it's unsafe, versus arguing about the remote instruction issue. So that should simplify some matters, at least in the reopening process. Another development, which Katie alluded to earlier, is the fiscal issues that school districts are facing, which unfortunately look like they're going to be getting worse before they get better. It was, just as a recap, back in June, the state budget contained, back in the spring, our state budget had a very unique structure as it pertained to municipal and school district financing that has not been, to my knowledge, is completely unprecedented. And that is that the budget contained essentially a clawback provision where the state set the budget that it expected to be available for municipalities and school districts based on the budget that was in place last year. So in other words, the state aid being allocated to public school districts and municipalities is the same as what was allocated last year. School districts don't like this very much because their costs have many escalations in them that happen regardless of school district spending. So as a result, costs do tend to increase due to unfunded mandates. So stagnant aid was a problem in and of itself. But now things are getting worse insofar as there was this clawback provision in the budget that provided that the state may go back and reassess how much aid is due to school districts if the net revenue of the state was insufficient to meet operating expenses. Well, that is what has happened because the federal stimulus money with respect to municipalities and other local governments is not forthcoming. As a result, the state is now threatening to assess a 20% reduction in foundation aid to all school districts and municipalities, which would be pretty catastrophic for school district operations. School district budgets were approved back in July as a result of an earlier executive order. A question that's popped up a lot and that may be occurring to you if you're a taxpayer in a district on the line is, well, the district already set its budget, so how can the state be going back and clawing back how much money that it's giving to the school district? The simple answer is the budget is a cap on spending. It's not the minimum amount that the district can spend, so revenues can be altered. This actually happened back in 2009 with a gap elimination adjustment that was applied by the state as well. The only positive development in this respect is that yesterday the governor did sign a bill into law that will permit school districts to access previously restricted funds that are in municipal reserves to be able to pay for unexpected expenses. School districts are required by law to only reserve up to 4% in unappropriated fund balance, which is essentially their unappropriated, operating expenses fund, and everything else must be placed in a designated reserve fund. And once the funds are reserved, they can't be accessed. Well, the good news is they have been given some flexibility in the short term, at least, to access those previously restricted funds to be able to pay for a program and for instructional programs for kids, as well as for COVID response costs. So the only other big development I do want to touch on is yesterday the governor issued a press release that is exciting to any of you who are the parents of student athletes, I would think, which is that whereas the state guidance up until this point has prohibited intramural or school-sponsored sports, the governor has issued a press release stating that schools may begin school-sponsored sports in all regions beginning on September 21st. Now, travel for practice or play is going to be prohibited outside of the school's region or contiguous regions or counties until October 19th. So there will be a delay for that. However, the lower and moderate risk sports may proceed with in-person practices at the school districts themselves. So that would include tennis, soccer, cross-country, field hockey, and swimming. There is prior Department of Health guidance regarding sports and recreation that we expect will be highly instructive as to school-sponsored sports as well, although that guidance has yet to be issued. We'll have to give you an update about that in a future webinar once it is issued. Also important to note that one of the gaps at this time is that the New York State Department of Education guidance, which remains operative for all public school districts and state-supported schools, does currently state that sports are restricted. So that will obviously need to be updated before schools will have the authority to proceed. We are also expecting that there will be further updates in this topic from the New York State Public High School Athletic Association, because they have previously established a COVID-19 task force that's consisting of various athletic directors and administrators from around the state to review guidance and put in place recommendations for school district sponsored sports and other athletic activities. So I did see an update from them yesterday that there is hopefully going to be guidance forthcoming that will be instructive as to how these athletic activities will progress once school is reopened. But at least at the current time, athletics may move forward for low risk activities, which is probably great news for all of those of you who are parents of kids that are eager to get back on the field. So that's all I have for today, Pete.
Thank you, Kate, and thank you everyone for being with us today. We appreciate it. It's good to talk with you on a weekly basis. Thanks for being friends of the firm and clients. Everybody, please stay safe out there, and we'll talk to you next week.